temperament of our judges. And so I asked today, what problem, Senator Garrett and members of the Republican caucus, is this bill trying to solve? What presenting issue is there? Because as Senator Hogue pointed out earlier, we have a system of justice for businesses, for people that want to have issues of probate. We have family courts. We have criminal courts. We have personal injury. We have drug courts, mental health courts. And while there's probably a decision or two people could point to that they don't like in that system that Iowans take advantage of and depend on, businesses depend on, people depend on, well, there may be a decision or two, we haven't heard about it, right? I think we could all say nobody's getting email on this other than from like one organization about why we need to change how we select judges. So the system seems to be working pretty well until you get to the hot button social issue court. Hot button social issues. And that's why we're here today. That's why we're here today. We're here because of the decision around marriage equality. You folks still don't like the fact that gay people who love each other and want to spend their lives together can get married. You still can't believe that happened. Don't like it. More recently, the decision by the courts to strike down the restrictions on women's control of their own bodies, to have a legal procedure. Abortion, by the way, is a legal procedure. You don't like those decisions that were recently handed down on 72-hour waiting period, Senator Garrett, or the 6-week ban. The hot button social issues. That's why we're here right now. That's why we're going to upend family court, probate court, business court, criminal court. That's why we're here. Senator Garrett wants to talk about judicial activism. He's your leader on this, you know that. He hasn't told us which case it is. But we know what case it is because we've been told what case it's been by the family leader. That's who's driving the bus here. The extremists are driving the bus here. You're ready to throw out a perfectly working legal system of justice in this state for these extreme viewpoints. Senator Hogue talked about it. It's arrogant. It's a power grab. You're drunk on power. We see it in other bills. And all because the Iowa Supreme Court has made some decisions you don't like. No guarantee under your new system that we're going to get different decisions. You know, we're going back to 1962 here to overturn what the people of Iowa said they wanted. You know, we've got new constitutional amendments proposed on stuff you don't like, and you're going backwards, tearing up constitutional amendments the people passed. I hope before we're done, Senator Garrett, you give us a little look inside at what decisions you don't like, because you're making one big change here by throwing around the term judicial activism. Fox News, let's hear what the cases are you don't like. Because Iowans deserve to know. They deserve to know from all of you on this issue. What is it? You're throwing out a perfectly fine system of selecting judges because you don't like a couple decisions. And I guarantee you, times will change. Different people are going to be in charge. Be careful what you ask for. Vote no.
Just for the information of the body, technical issues are preventing us from removing Amendment 3020 from the board. So just for clarification, just so everybody knows, we are now back on the bill as amended. We've disposed of all amendments. The chair recognizes the senator from Story, Senator Quirmbach.
Well, thank you, Mr. President. I, too, rise in opposition to this bill. And let's call it what it really is. It's a sore loser bill. When you cut through all the legal mumbo-jumbo, that's what it really is. And ironically, there is historical precedent for this. Franklin Delano Roosevelt, one of the greatest, if not the greatest president this country's ever had, the president who led the United States out of the Great Depression, who led us to victory in World War II, who served longer in that office than anybody ever had or ever will. In 1937, he was a sore loser. A number of the pieces of legislation that he had put through the Congress in his first term had been knocked down by the United States Supreme Court. And FDR's sore loser reaction was to attempt to pack the United States Supreme Court, to nominate additional judges, ideological supporters, so that he could get his way. Well, it didn't happen. It didn't happen even though one party, the Democratic Party in that case, controlled not just the executive branch, but it had overwhelming majorities in both the U.S. House and the U.S. Senate. It didn't happen because Democrats in the U.S. Senate stood up against their own president. They stood up for the constitutional system of checks and balances. They stood up for the independence of the judiciary. They stood up for the rule of law. They had the courage and the integrity to put their loyalty to the Constitution over their loyalty to party. FDR's sore loser reaction, his attempt to undermine the independence of the judicial branch, was defeated. Today, the Iowa Senate is faced with the same challenge. Will we today have the courage and the integrity to stand up for constitutional checks and balances? Or will we betray our oaths of office and our duty to defend the Iowa Constitution, our sworn duty? The majority party has indeed lost several Supreme Court decisions in recent years in the Iowa Supreme Court. In 2009, the Iowa Supreme Court adopted the radical notion that the word equal meant equal, that all Iowans were entitled to equal protection under the law with regard to the civil contract of marriage. Republicans had fought long and hard to prevent this development, but they failed. They even attempted to amend the Iowa Constitution in 2004. And I well remember that night. The Republicans had a 29-21 majority. And every Democrat stood against that amendment, including some in some rural districts where it would have been popular. But we didn't have the numbers by ourselves. We had 4 Republicans who had the integrity and the courage to stand up for equal protection under the law, to stand up for constitutional principles. One of those senators lost her seat over that in a subsequent primary election. The Iowa Supreme Court, in the Varnum decision, simply concluded that equal means equal. Hardly a radical notion, and indeed a conclusion that was affirmed just 5 years later by a ruling of the United States Supreme Court. Having lost in the Iowa Supreme Court, Senate Republicans now seek to pack the Iowa Supreme Court with their ideological allies. That is what this bill is all about. Similarly, Republicans have tried to take away a woman's right to control her own body, to control her own reproductive medical care. The Iowa Supreme Court last year defeated that effort. 45 years after the United States Supreme Court recognized a woman's right to choose, the Iowa Supreme Court belatedly recognized that the Iowa Constitution provides the same protection for individual rights. The Iowa Supreme Court took 45 extra years to so slowly reach the same conclusion that the United States Supreme Court had reached in 1973. Hardly an example of judicial activism. Once again, Iowa Republicans were disappointed and frustrated. They lost in the Supreme Court. And the result is the bill that we consider today. I am humbly asking all of my Republican friends to set aside their disappointments as sincerely as I know they are held. I am asking you to answer to a higher call. I am asking you to put your oath of office above any ideology. I am asking you to put your loyalty to the Constitution above your loyalty to party. I am begging you not to destroy one of the crown jewels of the state that we all love, the independence of the Iowa courts. I'm reminded of a famous scene from the play, later the movie, A Man for All Seasons. The movie recounts the historical conflict between Sir Thomas More and King Henry VIII, ironically, over another marriage issue. But in the scene that I'm recalling, Thomas More's hot-headed son-in-law wants to use all means necessary to achieve some political objective. Sir Thomas cautions him. He asks him what would happen if he pursued the devil across the length and breadth of England, knocking down all barriers, using all means necessary, and when all the laws were laid flat, and when all the protections were leveled, Moore asked, what winds will blow? No, we defend the law, we defend the Constitution, we defend the system of checks and balances for the same reason, for our own protection. My party, the Democratic Party, is not well populated with saints. We have a few, I think, but by no means a majority. Your party, my friends, will not hold the majority forever. A day of reckoning will come. Think about the politicians/judges that some Democrats will wish to appoint. If the travesty of this bill becomes law, you will rue the day that you ever voted for it. Please, 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 honor your oath of office. Protect our system, protect the Constitution, protect the independence of the Iowa judiciary. Vote no on this bill.
The chair recognizes the senator from Lynn, Senator Mathis.
Thank you, Mr. President. We've had some expert opinion here today from a couple of lawyers. Someone who works for the DCI is very close to law enforcement and the judiciary. we've had opinions from our constituents, and one of them in particular, Senator Capuchin, you know Pat Baird, who came here last year and presented to the Infrastructure Committee about the School for the Blind in Vinton, and was working on a project and that would benefit your district. Pat is a business person. We haven't really heard how this bill would affect the business community, in what way it would affect. And Pat is the retired president and CEO of Aegon USA and Transamerica in Cedar Rapids. And he also serves on several boards. He's been on the chamber board for years, and he travels all across the world, and more specifically in Mexico recently. He learned how to speak Spanish and now does a lot of work in Mexico. He's an entrepreneur, kind of a Renaissance man, and he wrote an op-ed, and I'd like to read it to you today. We haven't heard much from ABI. In fact, they didn't even declare on this bill. So this is in an effort to, I guess, give that business viewpoint. This is by Pat Baird. I've seen dozens of opinion letters in publications across the state about the proposed legislative changes related to the selection of judges in Iowa. But there is one perspective that I have not seen expressed, so I want to share it. I spent my professional career at Aegon USA, Transamerica in Cedar Rapids, retiring as president and CEO a few years back. I currently sit on the boards of Cedar Rapids Bank and Trust and F&G Life Insurance Company of Des Moines, as well as the board of ICR Iowa and the Cedar Rapids Airport Commission. While at Aegon Transamerica, while not a lawyer, I was the business person responsible for overseeing the company's litigation. When the company was trying to pick among 8 locations within the U.S. to grow our business and to choose a state of domicile for our regulated insurance entities, our main criteria for selection were quality and cost of labor, overall cost of living, and the fairness and consistency of the state's judiciary. If a state elected its state court judges or had another more political process in selecting its judges, it was not considered. In fact, we chose not to do certain parts of our business in those states where politics reigned in its judiciary. We chose Iowa, as other insurance companies have done, in large part because of its system of keeping politics out of the courts. Therefore, I have deep concerns over the legislative proposal to move the nominating process for judges away from the nonpartisan Iowa Judicial Nominating Commission that exists today. Under the proposed law, instead of citizen attorneys getting the opportunity to vote on something of the nominating commission members passed on their professional reputation, political party leaders in the legislature would gain that control. No matter how you cut it, the proposal existing in the legislature injects partisan politics into the selection process. Just having a proposal of this kind introduced in both the House and Senate is chilling for business. The current nominating commission process allows the current governor to select half the members. All judges are subject to a retention vote by the citizens. There is already enough political consideration and accountability to the people. In fact, if it were up to me, I would try and remove all political consideration except for the retention vote. But you know what? Not only is the current system not broken, it works really well and is the envy of most other states. Iowa has been blessed with judges who ignore politics, are faithful to our Constitution and the rule of law. Judicial rulings over our state's history have been consistent and fair. I can't imagine the unintended consequences of putting politics first and foremost into our judiciary. I can tell you, however, that as a business person and lifelong Iowan, this is an extraordinarily scary and chilly proposition. The governor and legislature have proposed plenty of initiatives that will make Iowa a more attractive place to do business. But I assure them, from experience, this is likely to have the opposite effect. Thank you, Mr. President.
The chair recognizes the senator from Polk, Senator Boulton.
Thank you, Mr. President. I, too, rise in opposition to this legislation. Qualified nominees to our courts matter. It matters a great deal. As Senator Bolkcom pointed out, time and time again, our nominating system has been recognized as a model for the nation. It's not a model for the nation for Democratic groups or Republican groups. It's pretty universally recognized as a system that gets it right, that tries to keep politics at an arm's length in the system and focuses on credible qualifying standards for our nominees to be chosen. And it's in large part because we have a process that ensures that our nominating commissions are made up of people who are qualified to be there too. What we're threatening to do here disrupts a very core, fundamental, basic concept in this state. It's our state motto. It's on the flag that sits behind the President of the Senate. Our liberties we prize and our rights we will maintain. That means something, and it's meant something to our judicial system from the very beginnings of our state to the very beginnings of our territory. We have a territorial decision from 1839 in Ray Ralph, where we stood up and we told the world, no man in this territory can be reduced to slavery. It started a proud tradition here in Iowa, that our rights matter, that our liberties matter, and that our judicial system is there to protect those rights and those liberties. What this legislation is doing today is disrupting that proud tradition. We should be hanging our heads down, embarrassed of this discussion in a state with that proud tradition. That tradition that has continued after we were a territory and became a state. We heard from Senator Lofgren earlier in this session about the Muscatine case, the Clark case, Clark versus Board of Directors in 1868, where we told the nation segregation is not going to happen in our schools. Not going to happen here. And it wasn't after we were told that that was going to be the standard. We led the way. Because we focused on justice. Because we focused on doing the right thing for our residents. People who live here that count on a judicial system that will protect their rights. And here we are having this discussion, as Senator Bolkcom pointed out, because of a few hot-button political issues. We want to disrupt a system that has served so well to protect our citizens. The focus should be on justice. We want to know that when our cases and our issues become topics before our courts, that they're going to be decided on the merits, not skewed by a partisan ideological process. We want to know that our judges aren't looking over their shoulders to determine whether or not their rulings will look good on a 30-second political ad. We have two branches of government that focus on that. We need one. We need one that has a safeguard. We want to cultivate a positive environment for business in this state, as Senator Mathis pointed out. Time and time again, we have companies who want to locate to Iowa because they know that our judicial system is going to be reliable, that it's going to be predictable, that it's going to follow long-standing case precedents, not shifting political winds. We want to know that we are a state committed to the integrity of our judicial system. This legislation is about justice. This is about trust in our judicial process. What this does is it taps that first domino. And as that domino falls, we will see our courts go further and further into the realm of politics, electoral politics and campaign politics, rather than staying focused on protecting our rights and our civil liberties. This won't be fixed when there's a change in administrations. The fix won't be to go back to the old system because it worked well. No, the fix is going to be eventually when we have a change in administrations, the focus will be on undoing the harm by repacking the courts. We could lose control of that system here today, and it will be so hard to ever get it back. We want this to be a state that focuses on that motto, that focuses on protecting our rights and our liberties. We want our judicial system to be the place we know we will go, and that will be the focus. What this does is it sacrifices justice purely for politics. I urge a no vote.